Lawyers of Reddit, what's your most badass I rest my case moment? I was on the losing end of this one. I was representing a pro bono defendant who was attempting to regain custody of her children. The family division attorney was laying out his case to the judge for why my client wasn't ready, and his final point was that my client had refused emotional counseling to avoid violent fits of rage that she had inflicted on her children. On cue, my client jumps up, screaming, "Screw you, judge lady! I hate you! Screw you all for taking my frickin' kids, you frickin' jerks!" I just caught the opposing attorney's smirk of satisfaction as I got up to usher my client out of the courtroom. Story 2. Not a case-winning moment, but a motion-winning one for sure. Think of cases like a big conflict, with motion hearings as little conflicts. Opposing attorney was insisting that Rule A meant they could do X. I tried multiple times to point out that Rule A literally did not say that. During the hearing, the judge reached behind them, grabbed their Rules of Civil Procedure, basically a dictionary of rules, placed it in front of the other attorney, and said, "Show me where Rule A says X." Other attorney did not take the hint, reads rules aloud for 5 brutal minutes, and then gave the book back. At the end, he said, "Judge, I have nothing to add." It was pretty fun. Story 3. Opposing counsel decided that I had coached my witness and gave him lines to repeat, that he was lying, basically. Short version is that he asked the witness if he spoke to me before he testified. Witness said he had. Attorney looked like he thought he had me. Attorney asked the witness what I told him, what instructions I gave him. Witness looked him dead in the eyes and said, "First thing he told me was to tell the truth no matter what. He said the lawyer's never the one who goes to jail, that he isn't going to go to jail for me, and if I lie, I'm on my own." Attorney looked like someone took the air out of him. Everyone in the courtroom simultaneously looked at me. Only time I've smirked or laughed in court. I wanted to put my feet on the table like I was Vincent LaGuardia Gambini, hands behind my head, and say, "I'm done with this guy." Story 4. Corporate lawyer, so I don't have cases to rest. But once, opposing counsel was forcefully insisting that it was ridiculous for me to expect a certain provision in a contract we were negotiating, and I pointed out that this provision was standard in his own firm's contract forms, as I knew from several prior transactions I'd worked on across from them. Pretty exciting stuff. He took it in stride and said, jokingly, "Well, of course it's fine when we ask for it." And it's always nice when someone responds to a moment like that with a bit of jokingness and being like, "Okay, you got me, fair enough." I respect that. Being able to admit when you're wrong or made a mistake, that's huge in my books. Good on you, opposing corporate lawyer. Story 5. I represented a company that was sued for a breach of contract by a former independent contractor. Dude basically alleged my client wasn't paying him correctly in accordance with the contract. During his deposition, Dude admits that he never reviewed any documents to make sure his allegations were true, never reviewed his complaint before filing it to make sure the allegations in it were true, and had no idea whether or not my client actually failed to pay him in accordance with the contract. Basically, he tells me that he was suing my client because he didn't think their agreement was fair, even though he agreed to the terms when he signed it. The kicker is that he admitted he owed my client money. At arbitration, he tries to flip his story, starts giving testimony that is the exact opposite of his dep. So I whip out his transcript and undermine his testimony bit by bit. Needless to say, I won that case. Story 6. Defendant in a bench trial for a speeding ticket said he couldn't possibly go as fast as the officer clocked him. He knew this because he videotaped himself accelerating from a full stop to the location of where the officer sat. His experiment showed the vehicle could only get to 55 and not the 67 he was clocked at. The ADA then moved to have another speeding ticket issued because the actual posted was 50. I feel like going 55 and a 50 is not uncommon though. Like, people just do that, right? I guess you could be taken to court for it or get a ticket for it, but usually they just wouldn't bother. I guess they figured, well, hope he's already there, so might as well. Story 7. Complaining witness accused my client of harassment/stalking. She said she told him numerous times that she wanted nothing to do with him. My client claimed they were dating, but whenever she got mad at him, she would call the police and say he was harassing her. On the stand, she testified that she'd never dated him, never invited him into her home, never wanted anything to do with him. She presented a photo on her phone of him sitting on her porch to prove that he had come onto her property. I asked the judge permission to look at the photos before and after the porch photo for context. Girl had dozens of photos of the guy who was clearly her boyfriend. I showed her one such picture. "This is Mr. So-and-so, right?" "Yes." "In this photo, he's, on a bed?" "Yes." "The bed is yours?" "Yes." "The bed is in your bedroom?" "Yes." "You took this photo of him?" "Yes." "He's smiling in the photo?" "Yes." "And in this photo, he's wearing your brassiere?" "Yes." No further questions, Your Honor. Story 8. I'm not a lawyer, but I was in traffic court one time and saw a lawyer straight up murder a cop with words. The cop had previously testified that the weather on the night of the traffic stop was heavy rain, and winds so strong that the defendant could only open his window 3 inches, and that the car had stopped in an area with very little shoulder, forcing the cop to approach from the passenger side, not the driver's side. The cop had then testified he smelled a strong smell of alcohol on the defendant's breath. When the defense lawyer got up, he repeated what the cop had said almost verbatim, and asked how he could have possibly smelled alcohol on the breath of someone on the other side of the car through a 3-inch crack in the window on a night with pouring rain and strong winds. The cop sort of opened and shut his mouth a few times, squirmed around in his seat, and said, "That's just what I always write in my log to remind me that it was a DUI stop." The judge threw the case out. No motion to dismiss needed. Then he took a breath and called the traffic prosecutor and the cop into his office. I'm guessing it wasn't for a nice spot of tea and some scones. Story 9. I'm relatively junior, so I'm hoping to beat this one day. I defend professionals and brought a motion to dismiss a case on the basis that the plaintiff could not prove my client was negligent, as she had not served the required expert evidence. As opposing counsel and I waited for our motion to be heard, we were sitting in the courtroom. The judge, who I did not know and who had not read our materials, wanted to talk to the parties of a short trial which was to be heard after our motion was argued. That matter was also a professional negligence matter, and the plaintiffs had no expert support. The judge then spent 10 minutes explaining that he had practiced in professional negligence for many years, and was well versed in the evidentiary requirements to prove the elements of professional negligence. In fact, he said, straight up, "I very rarely use the word impossible in this courtroom, but it is impossible for you to be successful without expert evidence." Our matter was then called, and I reveled in explaining to the judge that he was about to hear a motion to dismiss a professional negligence case on the basis that the plaintiff had no expert evidence. I won. Story 10. We had a case where opposing counsel was cross-examining our expert witness on hydrology regarding some silt/runoff issues. "Mr. Smith, wouldn't you agree that the book I'm holding is highly respected in your field and considered to be the gold standard on the subject?" "I am aware that it is highly regarded in my field." "Would you be willing to explain in your own words what paragraph 6 to 10 on page 121 is describing?" Witness reads the passage word for word. "Yes, I can read, but could you put this passage in your own words for the court?" "These are my own words. I wrote it." We were the defendants. We were being sued by an HOA over silt in a lake. We were able to prove that we weren't responsible and prevailed. It actually originated from another site and entered the lake elsewhere. However, that site was owned by a very large corporation, and I don't think the HOA wanted to fight with an entity that could fight forever. Okay, I know this isn't the point of the post, but that end kind of ticks me off, you know? Like, oh, because this company has a lot of money, they can get away with doing something that a smaller company couldn't. It's not any less bad. In fact, it's probably worse because it's on a larger scale. But because they have the money, they can't be gone after for it. God, that makes me so mad. Story 11. I do mostly solicitor work, so if I'm doing my job right, I don't get a whole lot of these types of moments. That being said, I had a longtime client who was being sued, and I got to shut down the guy suing him in a very satisfying way. So my client had hired a guy who we'll call Kevin, basically as a right-hand man for his company. The employment contract wasn't done yet, but they had an agreement that Kevin would work 6 weeks at a lower wage and then sign the contract and get the agreed-upon wage. So the guy works decently for 5 weeks and then is given the contract to sign. He comes back to the owner, my client, and says that he has some small changes he would like to make. When the owner gets the contract back, he finds the small changes involve removing the duties and responsibilities section, basically the job description, and the non-compete/confidentiality clause. Not only that, but he has written in a higher salary than agreed, and added a bunch of new benefits for himself. Obviously, my client tells him that he can either sign the contract as it was originally laid out, or find himself another job. He takes the latter, but he starts a lawsuit against the owner wanting to be paid for the 6 weeks he was supposed to work, which had already been paid, by the way, as well as 2 weeks in lieu of notice and 5 weeks vacation pay. I got the enjoyable job of telling Kevin in front of a judge that he was not entitled to anything under the employment legislation, and the only way he could get any of that would be if he signed the contract. The judge dismissed the case and awarded costs to the defendant, but not before giving Kevin a lecture on wasting the court's time. Story 12. Not a lawyer, but during a particularly nasty employment mediation hearing, I got to ask my former employer a question about payments per employment law. Me. Did you or did you not pay into state-mandated unemployment insurance fund for all your employees past and present? Silence. Mediator. Sir, answer the question. Silence. Well, let me ask it. Did you or did you not pay into state-mandated unemployment insurance fund for all your employees past and present? Silence. I'll take that as a no. Story 13. As a young attorney, I had stated a claim that an insurance company was dragging out a case in bad faith, in hopes that my elderly client would die before they had to pay him. I was requesting that the trial date would be given priority due to my client's advanced age. The judge was no spring chicken himself, and seemed skeptical when he asked exactly how old my client was, maybe thinking he was in his 70s and must merely seem ancient to a baby lawyer like me. When I responded my client was 92, and the case had already gone on for 5 years, the judge was visibly shocked, and immediately granted my motion for priority, shutting down the insurance company's attorney's attempt to respond. They wrote us a check for $1 million next week. Story 14. It wasn't at trial, though we had one of those and I won it easily. Just always stuck with me because of how clearly the law supported my position to the point that it was inarguable otherwise, and also because of how ridiculous the claim of monetary damages was. So, guy moved out of his apartment, turned in his keys, and then came back 15 days later demanding access, because he wanted to retrieve belongings that he had left behind, which at that point had been trashed. It was just some minor furniture type stuff. Lampshade is the only thing I clearly remember, as well as a box of his college notebooks, notes he took during class. He is furious. Sues the landlord in small claims for $5,000 state maximum, because his notebooks have huge value apparently. They hire me and I respond, which moves the case out of small claims. I know this isn't the case for every state, but our rule is better than yours. Anyway, moving on. This puts him at a huge disadvantage, because now he can't rely on the lax rules of small claims, so he goes out and hires a lawyer. The lawyer calls me and tries to talk settlement. I know her pretty well, so I wasn't rude or anything, but I kind of scoffed and was like, no, that won't be happening, and directed her attention to a particular state statute and then read it out loud to her. The statute, unlike everything else in the law, isn't overly long or wordy or hard to follow. It just says bluntly that when someone actually moves out and gives notice of this, items left after 10 days are abandoned. Period. End of story. I could feel her deflate on the phone and encouraged her to dismiss the suit. She didn't. We proceeded to a short bench trial in district court that we won. Yeah, well, it's pretty cut and dry, huh? That must be a really satisfying moment for a lawyer, just to be like, yep, I got you, dead to rights. There's literally nothing you could say. Poor other lawyer. Story 15. I have two that I like to share. I'll apologize up front for the length of my response. The first involved a lawsuit against the owner of a Mexican restaurant for not paying his employees and keeping the waiters' tips. He was just an all-around terrible guy. He created these fake handwritten schedules and payroll records going back years to try and prove that his employees didn't work but a few hours each week and were paid for what they did work. It was difficult to prove they were fakes, but we managed to trap him during deposition. I made the guy go through random bits of his work schedule and asked him to confirm they were correct. We did a random week in February, March, April, and then we got to May. So, here in early May, you had 2 servers working every night. 1 hostess, 1 bartender, and 2 cooks as well. Yes. And that didn't fluctuate. You didn't have a need for extra staff on, say, weekend nights? No. It was very steady no matter the day. What about on this Wednesday? How many staff did you need? Just the 2 servers, my hostess, the bartender, and 2 cooks, the same as every other night. And if you'd indulge me, what date are we looking at? May 5th. Okay, so it's your testimony under oath that you had the same staffing needs on May the 5th as you did on May the 4th and May the 6th. Yeah. Opposing counsel's head begins to hang while shaking. So you're comfortable telling the judge you didn't do extra business on May 5th. Yeah, or June 17th or whatever date you pick. It was always steady. You have no problem walking into court and telling the judge and the jury under oath that your Mexican restaurant didn't need any extra help on May the 5th, that these schedules and payroll records you've produced are 100% accurate for Cinco de Mayo. You are totally comfortable with doing that? Yeah, The case settled within a week. And number 2, state law enforcement was trying to prosecute a local cop for accessing name and address information for an individual in the state's criminal justice computer to help a friend who was a process server. The state was prosecuting the cop for violating the Computer Crimes Act, which in part makes it illegal to share any information which the state has an intellectual property interest in. We show up for trial, having waived our right to a jury, and allow the head of the Attorney General's litigation department to make this wonderfully colorful speech about a police officer breaking the public trust and this other nonsense. For our opening statement, we move to dismiss the indictment on the grounds that the state's theory of the case is a legal impossibility. The state can't have an ownership interest in someone's name or address. The judge was annoyed with our tactic and put the screws to us by asking dozens of questions, but we kept repeating our theory. The state cannot own a name or address as intellectual property. Finally, the judge gets it and turns the question to AG. He tries to dance his way out of answering the big question all sorts of ways. Eventually, the judge flat out asked him if he contends the state can own someone's name or address. The AG responds by saying, "Judge, I came here to try a case, not to argue the law." The judge wasn't impressed. dismissed the case immediately and wrote a letter to the Attorney General asking him to be more selective in his prosecutions. That was a fun day in court. Story 16. I helped the prosecution rest his case. I got jammed up during spring break doing dumb spring break stuff. So there I was in court to face the music, misdemeanors. As I sat there waiting for my turn, I watched person after person go before the judge. The prosecutor read their charges and some information from the police report, stating what the potential max sentence was for each/all, I don't remember exactly. Then the judge asked what plea they wanted to enter. Almost everyone said not guilty, and I could see that both the judge and the prosecutor were getting tired of their BS. Finally, my turn came. I was probably the second to last after what seemed like hours, but may not have been. The prosecutor read off my charges and cited the police report. The judge looked at me with this, let's get this out of the way, look, and asked how I pled. Guilty, Your Honor. The judge and the prosecutor both looked at each other, and the judge said, kid you not, say again? Or, beg your pardon? One of the two. Guilty, Your Honor. I did it. Just the way Officer So-and-so's report reads. They exchanged looks again, and the prosecutor held his papers at arm's length as if to get a better look at them and did the unthinkable. Your Honor, this reads to me like a case of a college prank gone bad. The county moves to reduce charges to XYZ. I walked in there expecting some jail time, and walked out paying like $110 plus costs. I didn't really know how to feel about the scariest day of my life turning into one of the happiest ones. Story 17. My client and his wife were woken up one night because people were trying to break into his house. He fired 2 warning shots as his wife called 911. The neighbor also called 911. When the police got the neighbor's call that there were shots fired, the police sergeant radioed the other officers, saying, "He's going to jail tonight," referring to my client. So obviously, even with signs of someone trying to break in and his wife calling 911 for help, the officers arrest my client for endangering his wife by shooting inside the house. Nowhere near her, by the way. It gets to a jury trial and I start to go off on the police sergeant about why he would say that before an investigation. And before he even had any idea what happened, the sergeant had no idea how to respond, and literally just sat there staring at me for a solid 2 minutes before saying anything. Even the bailiffs were audibly laughing. Story 18. I am not a lawyer and I've told this story before, but it always makes me smile. I was in court to get more placement for my 2 kids. My ex-wife and her sister were claiming all sorts of things, that I was abusive, a stalker, an assaulter, and so on. Like, to give you an example of what they were pulling, they claimed I choked my daughter, and then they brought her to the doctor on October 2016. The doctor brought in a second doctor, and they both looked at the marks on her neck and were like, we can't exactly call the police for this because it's unclear. I pulled the doctor's records and the appointment never even happened. So there were a few moments. One was that they were claiming that I angrily hauled my son out of their house because he wouldn't put on his shoes or coat in the wintertime. Now, while I did take him out of the house, it was because they had been arguing for 10 minutes with a 4-year-old about putting on shoes and a coat in winter. They had only gotten his shoes on. So I picked him up and took him to the car. Then he stopped me and wanted to put on his coat. So this was their big moment. He looked so angry and hauled son out of the house. My attorney has my ex's sister on the stand. She's already unsteady on the stand, muttering and not answering questions clearly and trying to lie without lying. So my attorney asks, why did you think it was unnecessary for OP to carry son out of the house? Because you can reason with son. He's 4. You really think you can reason with him? Yes. So, in this case, did it work? She froze, like literally froze. For about 5 seconds, she didn't say a thing. 5 seconds doesn't sound like a lot, but when you're on the stand and everyone is staring at you, it feels like forever. Finally, she said, well, it usually does. But in this case, did it work? Well, it usually does. He moved on. But the best part, and the one where I could have flown, was toward the end of the trial. So my ex spent 8 hours spread out over days ripping apart my character. I was an assaulter, an abuser, violent, but also one time I sent my daughter home with the dog poop on her shoe. Murder, arson, and jaywalking is what we called it. Like, if he is so violent, why are you even complaining of that one time she had dog poop on her shoe? Anyway, so after all this time, she still never explained why she thought my daughter couldn't have more time with me. She made a lot of hints, but never nailed down any reasons in any communication she sent to me. Even in her deposition, she didn't say anything about abuse. So finally, my attorney nails her down on the last day and says that she's afraid that my daughter won't know that mommy's going to come back. Basically, that my daughter lacked object permanence. The judge asks her a few questions. He says, so, are your son and daughter close? Oh, yes, very close. Does daughter miss him when he goes to school? "Oh yes, very much so." "So does she miss him because she loves him, or miss him because he's not coming back?" "Oh, she knows he's coming back." "Okay." In the span of a minute, she torpedoed her entire argument. Her attorney saw it right away, but she didn't. They tried flailing around in the closing arguments, but it was all over. And I got more time with my children. Story 19. Two high school kids spend their day absolutely annoying the hell out of each other. So they decide to drive to a fast food restaurant to fight. They park, get out, immediately approach, and swing. Kid A connects the first blow squarely and solidly across Kid B and instantly drops him. The whole fight was one punch with a total elapsed time of a few seconds. The restaurant is sued for failure to protect its patrons. The case is weak. Unfortunately, Kid B hit the pavement hard and had severe brain damage. Attempts were made to settle, but they were after millions. We knew walking in they had two former employees testifying about large crowds building up after school. The plaintiff attorney aimed to prove that the restaurant had a reasonable expectation of trouble and should have had armed guards in the parking lot. At best, their witnesses wildly exaggerating to the point of perjury. Their credibility was shaky in the beginning, being highly disgruntled for being fired. We had a list of witnesses ready to refute their claims. At trial, the plaintiff attorney presented first. He spent a long time building up the bad blood between the kids, the serious damage of Kid B, and his potential earning capacity. A lot of foundation work to build sympathy for his client. We break for lunch on day 2, after which it would be the defense presentation. As we were walking through where we were and how we should proceed, we realized that the restaurant was not really mentioned at all. Plaintiff held back his star witnesses to rebut the defense presentation the restaurant was safe. So when we reconvened, "Defense rests, Your Honor." The plaintiff attorney fell out of his chair. He begins frantically shuffling papers on his table and was stammering. The judge says, "I take it you'll need a few minutes for your close." After that break, plaintiff's attorney gave one of the worst closing remarks I've ever heard. Jury: Kid B 10% at fault, Kid A 90% at fault, restaurant 0. Story 20. I was a second-year associate, and handling my first trial. I represented the plaintiff. The defendant had an expert witness who had testified previously in about 40 similar cases. This expert came out to my client's property and did a complete BS examination of the issue, and his expert report was equally as BS. For those of you who don't know, expert testimony needs to meet a certain standard, the Daubert standard, at least in my state, in order to be admissible. This guy basically took some photos and put a ruler on the ground a few times to make his report seem legit. The partners at my firm told me it wasn't worth trying to file a Daubert motion to strike his report/testimony because the case was low value, under $100,000, and those types of motions can be very complex, and didn't want to build a client for it. I was so angry about this guy being deemed an expert that I came in on a weekend on my own time and drafted a 20-page motion to strike his testimony. I didn't build a client a dime. The client didn't file a response to my Daubert motion to strike. Instead, they waited until right before the expert was set to testify. He had been sitting in court racking up fees for 2 full days beforehand. The judge had the jury leave the room, put the expert on the stand, and allowed the defendant to do a direct examination of their expert. The defendant's attorney, not taking my motion seriously, had their inexperienced associate, just like me, do the examination. It was incredibly basic and didn't respond to any of the points in my motion. I was in charge of doing his cross-examination. It was my first cross-exam of a witness ever. I tore the guy, a seasoned expert witness, apart on the stand. I got his entire testimony and report struck. They also had a second-hand expert witness who was pretty terrible but not quite as terrible. I also did his cross-examination. Realizing they were in serious trouble without their primary expert and the second expert at risk of getting struck, the lead counsel for the defendant, a named partner at a well-known firm, did the direct exam for the second expert. I again did the cross. I got the second expert's testimony struck except for one very, very tiny area. So essentially he was forced to testify with both hands tied behind his back. The most gratifying moment of my legal career thus far. I love the idea of someone getting paid to do something and then being like, you know what, no, this ticks me off, this is stupid as hell, and then coming in doing the work on their own time, not getting paid for it just because they're mad about it. Like, damn, okay, go off. OP had a point to prove, and damn it sounds like they proved it. Story 21. So I'm fighting a DWI case, and the cop is a lying liar who tells big lies about what signs he saw on the field sobriety test that my client was allegedly intoxicated. The state had not moved expeditiously enough to have a copy of all the evidence in the case, so we got him up on the stand talking all about how my client looked on the horizontal gaze nystagmus eye test, then buried him with his own body camera footage, which he thought had been destroyed. Oh, it wasn't. The judge, the newly elected Democrat in Texas, made findings on the record that the police officer had intentionally lied and misrepresented the truth. The state still tried to fight the case, but it came out the right way. Okay, what's the point of body cam footage if it can just be destroyed to disprove or not be able to prove any wrongdoing. I feel like that's very against the purpose, but whatever. What it really comes down to is a liar got blasted in court. Deserved. Story 22. So I call up my client's disgruntled former employee about a contract dispute that he started, and that got my client into litigation. After 2 questions, it was obvious he was a lying son of a gun. I didn't want to call him as a witness. He was prone to act unpredictably. I took down his story as we talked, which was easily proven false by documents and which cast my client in a false and bad light. I did not tell him how I'd caught him in lies. Fast forward one day. I submit a list of known witnesses to opposing counsel, as required by the rules. Witness number 1 was the lying sack of crap. Fast forward to trial, my opposing counsel calls the lying sack of crap as his first witness, and the lying sack of crap acts like a lying sack of crap. He tells the same story on the witness stand that he told me on the phone. I took emails that he wrote and entered them into evidence and proved him a clear liar. My client didn't breach the contract. The party suing did. After the lying sack of crap left the witness stand, I asked the court for a brief recess. Granted. I approached opposing counsel. My client was still willing to sign on to the walkaway settlement where no money changes hands and no fault was admitted. We offered the deal 2 months before and it was angrily rejected. Now, suddenly, accepted. Score. Story 23. Corporate lawyer, but this was on a pro bono housing matter. My client just needed to not lose her housing. I was trying to get her on 1-year probation, but would agree to 2 instead of termination. On the day of the hearing, I had 6 summer associates come with me, each carrying huge binders. When my hearing was about to begin, I had them all bring them in and sit them in front of me. The opposing lawyer was a very overworked NYC housing attorney who had budgeted an hour that day for my hearing. She instantly goes, "What is this?" I told her, "My arguments." She said, "I don't have the time." I started off on a 2-minute opening I'd prepared and then grabbed one of the binders and she was like, "Let me stop you there. What do you want?" I said 3 months probation. She countered with a year. Ended up agreeing on 6 months. The binders were all empty. Story 24. I represented a man in a slip and fall case in a national chain that grills chicken. The restaurant is not supposed to clean the grills until after they close because it is a huge, sloppy mess. It involves using a garden hose after applying chemicals to remove all the grease. The close down process can take up to 2 to 3 hours. It involves packing up the food for the next day, scrubbing the grills, mopping, etc. Even though the corporation knew this, they refused to pay more than 1 hour's worth of wages after closing. Thus, the shift managers and cooks decided they would start the closing process 2 hours before closing, while there were customers still in the restaurant. Now, this is really dangerous, as employees delivering food can track the greasy water into the lobby where the customers were. On one fateful day, 2 hours before closing, one of the cooks was cleaning the grills and using the hose to wash them down. This slurry is so slick that the cook has to wear a plastic smock and slip-resistant shoes for the process. While he was waiting for the chemicals to remove the grease, which takes about 15 minutes, the cook goes into the lobby tracking the stuff into the hallway to wipe down some tables. My client walks out of the restroom and slips in the greasy water. He hits his head so hard it causes a subdural hematoma, which requires surgery to relieve the swelling and blood from the brain. Go figure, the video system wasn't working that day. In any case, right after that, the cook was fired, and the corporation claimed they couldn't locate him during litigation. I did some research and found a relative of the cook, which eventually led to me finding him. He admitted that he was cleaning the grill, but denied he was the one who tracked the greasy water into the lobby, as did all of the other employees. The corporation during the entire 3-week trial testified that cleaning before closing was against their policy, and it never happens. Thus, it had to be anything else that caused my client to fall. I was talking to the cook before trial because we were going to call him as a witness. He was mad they fired him. I asked, "Do you think they're still cleaning before closing because they are denying that they do?" He told me, "Absolutely." On the first day of trial, I sent my investigator to the restaurant at the time my client was injured, which was 2 hours before closing. He was there to record video on his cell phone, whether they were cleaning or not, and guess what? They had the hose out and everything. I couldn't believe they would continue to do this at the restaurant at issue in the case. I told my investigator to go back up there when there was a different shift manager and cook to see if they were doing the same thing, and hey, they were. At the end of the trial, the defense put on their general manager for the region. He swore up and down this never happens. He was their last witness. We get up and say, "Judge, we need a sidebar." In the judge's chambers, we revealed the videos to the other side. The attorney for the corporation was freaking out. The judge let it in for rebuttal. The last thing the jury saw before going into deliberations was 5 minutes of video with audio of the hose as they were cleaning the grills 2 hours before closing. We completely wiped out their entire defense in a 3-week trial with that video. Needless to say, we prevailed. I should add, using sub-rows of video against a defendant like this is very rare. They usually stop what they're not supposed to be doing during the trial. I guess the restaurant, though, didn't get the memo. Story 25. Not a lawyer, but this is my favorite story in traffic court. I got a ticket going 75 on the I-88, near Chicago. The officer wrote on the ticket I was going 88 on the I-75, Detroit south to Miami, not near Chicago. I show up wearing a suit because I have one suit and hey, I may as well wear it. Judge calls on me asking if I'm a lawyer. I say I'm not, but I get to go first because I'm the only one in a suit. Judge looks at the ticket, says, "You were going 88 on I-75? Officer X, what does this ticket say? Isn't I-75 out of our jurisdiction?" At this point, I open my mouth and shut it. Because hey, I have the right to remain silent. May as well show the ability to be silent as well. Officer says, "Your Honor, at my age I have no idea what I wrote." Judge gives him a look, throws my license back to me in the plastic bag and says, "You're free to go." Always wear a suit to traffic court. Always wear a suit and apparently also always get pulled over by an officer who has no clue what they're doing. Like, why would you say that in court? At my age, I have no idea what I wrote. Bro, are you sure you should be doing this? I feel like this job may not be for you. Story 26. My 8-word trial would be up there. Basically, my lowest ever effort court hearing win. I was required to say a grand total of 8 words during the whole thing. The defendant's lawyer has screwed up spectacularly and has tried ineptly to get his client and himself out of the muck. He spends about an hour ranting and raving about the injustice of it all, screaming at the judge that he's got it wrong, while I sit, half listening, casually browsing Reddit and using the court Wi-Fi. Eventually, he gives up, and the judge says something like, "For, reasons, I'm going to dismiss this application. Anything to add, OP?" No. Word 1. Okay, application dismissed. How much are your costs? £12,000 plus VAT, a UK sales tax. Words 2 to 6. Granted. Good morning. Thank you. Words 7 and 8. Story 27. This isn't an I rest my case moment, but it was a damn fun cross-examination. I was defending an alimony case, and in my state, cohabitation with a new lover is a bar to alimony. We had a PI on the plaintiff's tail for a few months, and she and opposing counsel had no clue. I had a mountain of evidence that the plaintiff had moved in with a new boyfriend, and they were essentially husband and wife without the marriage certificate. So if I could prove cohabitation, she didn't get alimony. On cross, I'd set her up with a question I knew she would lie about, and then hit her with a photo contradicting her. So it's your testimony that John Doe never visited your house? Okay, so do you have an explanation for why he's walking in your front door in this photo? Oh, so he did come over but never stayed the night? I see. Do you have an explanation for why his car was parked outside of your building overnight on XXX and X nights as seen in these photographs? For a solid 45 minutes to an hour, I'd ask a question, she'd lie, and then I'd impeach her with a photo directly contradicting her. I was catching her in a lie per minute or more. And she never wised up either. After the first few times, you think she'd start telling the truth, but no, she just kept on lying. Again, it wasn't the flashiest or even an I rest my case type of moment, but the most fun I've ever had on cross. In the subsequent order, the court made the specific finding that the plaintiff's testimony was without an iota of credibility. Story 28. Back when I was a prosecutor, I had a defendant object that I couldn't compel him to give a fingerprint sample for comparison. It's how we proved up prior convictions. Our expert would fingerprint the defendant outside the presence of the jury, and in the presence of the jury compare fingerprints to the ones included on old judgments. This is 101% BS, because fingerprints aren't testimony and can be compelled. But the judge for the day was actually buying the argument, told the judge I was applying for a search warrant and asked to be sworn in. She swore me in. I applied for a warrant, and she wrote out a warrant return for his fingerprints. No longer with a valid objection, the defendant was fingerprinted and surprise, surprise, his 4 prior felonies were indeed his. He's serving life now. His crime? 2 weeks after getting out of prison, he bought some coke, which he then mainlined and then drove on. And while driving, ran a stop sign. When an officer tried to pull him over, he fled and threw his coke and needles out the window into a residential neighborhood, where he then crashed his car into a house. And when the officer got out to go check on him, he tried to run the officer over. The officer shot him in the chest and then performed a life-saving first aid until the paramedics could get there. Story 29. Several years ago, there was a big drug bust in my town where the cops arrested about a dozen people in this garage and charged them with manufacturing, delivery, possession with intent to deliver a controlled substance, drug dealing, conspiracy, and criminal organization, known as RICO in other places. I was appointed to represent one of the people found in the building when the drug task force raided the place. The police filed an 8-page affidavit of probable cause. Most are 1 to 2 pages for most other cases, detailing their surveillance of this criminal enterprise and the comings and goings of various participants and their roles in the enterprise. I read all 8 pages, and realized that the only place my client's name appeared was on page 7, where it said, "The following individuals were present at the garage when the warrant was executed. Person 1, Person 2, Person 3, etc." So he was there the day the drug task force raided the place, but there was no mention of his involvement in the criminal enterprise. His bail was set at $250,000, which is ridiculously high, and the district attorney refused to agree to a lower amount at his preliminary hearing. I filed a motion for bail reduction and showed up at the hearing loaded for bear. The DA calls the case. I approached the front, and the judge jumps right in before I could even open my mouth. Usually, counsel makes their arguments first. Then the judge asks any questions of us he has, and then makes a decision. The judge looks directly at me and says he's read the affidavit of probable cause. He says what's alleged in there is pretty serious and a big deal in our small town. He noted how the task force had the place under surveillance for weeks to build their case, which ultimately resulted in their raid. And if the allegations can be proven, the defendants are facing some serious consequences. But, he says, now turning to face the DA, he saw that my client's name appeared only once in the entire affidavit, and it makes no mention of his involvement in the drug enterprise. The judge asks the DA, "Why shouldn't I grant the defense's motion for bail reduction?" The DA stammers, we have the evidence that this defendant was involved with picking up the material from Philadelphia and transporting it here. The judge looks at the DA again and says, "Did I miss that in the affidavit?" The DA replies, "No, they just recently found that out." The judge turns to me and asks me if I have anything to add. There I was, fully prepared to make this passionate argument for why my client's bail should be reduced. The deficiencies in the affidavit, my client's advanced age, his lack of a criminal record in the past 20 years, etc. I stood there trying my best not to smirk and said, "Oh, I have nothing to add to your honor." Motion granted, bail reduced. Story 30. I had a family trial where the other party, the mother, had refused my client access to his kids for years, and just generally lied about everything. I can't remember the exact details, but I know I caught her in a stupid lie about when she got pregnant by showing that the date of conception is not the date they count from to determine how far along you are. My favorite part was after her going on about how terrified she was of my client, when I presented her with his phone bill, showing she called him 70 times over a few days during the period she had just explained she was in serious fear of him. Stuff like that doesn't happen very often because we have a discovery process, and I'd provided the phone bill to her lawyer ages ago, so she should have known it was coming, but I think it was a combination of crazy client who can't stop herself from lying, and a legal aid lawyer who had half a foot in retirement and just didn't care anymore. Most of court is pretty boring. Rarely are the gotcha moments there you see on TV. Actually, it drives me crazy when lawyers on TV get that moment and then say, "No further questions." Yes, there are further questions. Catching someone in a lie does not make your case. There are tons of other questions. Story 31. I'm not a lawyer, but I saw the best court moment ever. So there's this person I know that was charged with murder. He was very young and on the spectrum. After several hours of interrogation, he gave a false confession. The confession was complete horse hockey and contained details that were easy to prove as false. The defendant's lawyer is questioning the detective that was involved in the interrogation. It comes out that the detective attended a training course on how to interrogate suspects just 3 months before the defendant was arrested. In it, the detective was supposed to learn a specific technique that prevents false confessions. This technique was clearly not used when the defendant was questioned. Lawyer: "So, you learned specific technique, but didn't use it. Did you really not learn the technique?" I don't understand the question. I learned about technique at the training course. I know how to use it." "But you didn't use it. You are aware that the style of interrogation you used leads to false confessions."
I don't know what you want me to say."
"So, did you forget something you learned 3 months ago? Or did you purposefully not do what you were supposed to because you wanted the defendant to be guilty, no matter what the truth is?"
I don't understand the question.
"Are you bad at your job because you're incapable of learning, or is it because you don't want to find the real culprit?" The lawyer backed the detective into a corner for 5 minutes of what I'll paraphrase as, "Are you stupid or corrupt? No other option." Eventually, the lawyer took pity on the dumb cop and let him get off the witness's stand. The defendant was acquitted. This is a cruel way to get it done. And hey, I'm not saying it's wrong, but that detective was put on the spot. Fair question though. You learned it 3 months ago. Why didn't you do it? You either forgot or you didn't want to. Either one doesn't look so good for you. Story 32. So typically I do plaintiff's works for corporations, but one of my clients was getting sued by a former contractor for work allegedly performed right before he was fired in the amount of $150,000. I had never dealt with opposing counsel. She was about my age, 32, and seemed nice heading into trial. The day of our pre-trial, just 5 days before trial, she tells me in the elevator, "I hope you know I'm gonna kick your butt in trial." I laughed and she said, "No, Really, you are screwed. Trial comes and she drags out her case over 5 days. I start to get the impression her client made up the invoices with her help. She finally rests her case, and I called her client as my only witness. He immediately testified his attorney showed him how to make the invoices. The judge wouldn't allow them into evidence. She lost her case and was sanctioned $5,000 for falsifying evidence. She appealed and the Court of Appeals ripped into her. Needless to say, I did not get my butt kicked. Story 33. A lawyer friend of mine had this scenario. His client moved into a newly built office building, where they got to do a fair amount of construction work to arrange the offices on their floor how they wanted. As it turned out, there was this overly large gap between the lip of the elevator door and the floor, on the order of an inch or so. You wouldn't think that's enough for an issue, but it was leading to people continuously tripping themselves up. So since they were doing construction anyway, they paid someone else to do a small concrete pour to smooth things out and fix the problem. The original construction company finds out about this and uses their technically unconcluded contract to insist that they can rip up the floor and fix it themselves. They do so, and now instead of a small issue next to the elevator, the entire surface of the elevator lobby on that floor is ruined. Random half-inch dips and hills all over the place. There was basically no leveling of any kind done. Upon being told this was unacceptable, the construction company responded by sending the client a bill for the first redo, that they hadn't wanted done since they'd solved the problem, and a quote for fixing it. The timeline of these events was presented to the court, followed by an extremely scientific presentation on just how truly horrid this floor was, with high-resolution topographic maps of the surface presented, clearly showing just how bad it was. And then the lawyer, while talking with the lead engineer for the construction company, leans in and asks the question, "Is this acceptable work for your company?" The reason this is such a mic drop is that it is handing the construction company a win, but at great cost. If they say yes, then the client has to pay the first bill and would have to pay for a redo. But then the lead engineer of that construction company goes on public record as stating that shoddy work is considered acceptable by the company. If they say no, then the construction company eats the cost of the redo and the redo necessary to fix it, and goes on record saying they screwed up. A lose-lose situation. Very nice. Backed straight into a corner. And hey, it's their fault. If they really did that kind of thing and called it a fix or whatever, then clearly they believe it's the best they can do, or is at least up to the standard that they strive towards. And the world deserves to know about that. Story 34. A lawyer friend of mine had written a blog post about a legal subject. Opposing counsel filed a motion, in which they had to cite their reasoning for their arguments. In this particular motion, they chose to dig through the website of my friend where they found that blog post, which they chose to cite in their own arguments. Basically, they were going for an aha moment. You can't argue against us because you yourself once wrote something which we think agrees with our point of view. Rather than dispute the nitty-gritty details of their argument, my attorney friend simply responded with something along the lines of, "Oh, I'm honored to be cited as an expert in this area by my esteemed opposing counsel. Now, as their chosen expert, let me tell you what the law means and why they're wrong." It was glorious. They very quickly revised their argument. Story 35. I wasn't a lawyer at the time. This was a high school mock trial, but fun nonetheless. For those unfamiliar, mock trials are like normal trials, but fake. As a result, it doesn't go until arguments are exhausted, but instead each participant is given a time limit and has to make their case within that period. Also, everyone can go home in a timely fashion. The time limit for us was 10 minutes, but you could go significantly over if needed. Anywho, we were competing against a local school, in a case that centered around an alleged hostile work environment. I was one of 3 attorneys doing direct examination in my team, and my witness, playing the company's CEO, happens to be a close friend of mine, so we were well prepared. At trial, I get through all my questions, passed across, and that's when the fun begins. The opposing attorney got through about 6 questions before my friend gave an answer he didn't expect. Rather than simply moving on with his questions or jumping to another line of questioning, opposing counsel chose to repeat his question slightly differently. In a way, it would have been proper for me to object with asked and answered. I didn't. Instead, I sat there, silently, as this poor frickin' kid spends his whole time trying and failing to get the specific answer he wants out of my friend. So after 10 minutes of him restating his 6th question to no effect, I objected. The judge, sick of listening to the same question, said something to the effect of, "I would hope so. You spot my plan yet?" Rather than object the question had been asked and answered already, I simply stated the cross had used their full allotted time, and that he shouldn't be allowed to continue. Remember, he was 6 questions into his argument, so all he had gotten in his 10 minutes was my friend's name, age, place of work, job title, and that they had meetings at work. I shouldn't need to tell you, none of that is particularly useful. The opposing counsel looked very confused when he realized what had happened, and the judge kindly suggested he move past that question and finish his examination quickly. He moved on, got slightly further into his questions, but not far enough, and eventually had to stop due to time. Still nowhere near where he needed to get to. My score wasn't particularly high. After all, I missed an easy asked and answered objection for 10 minutes, but hey, higher than his. And we won as a result. Good times. Another mock trial story. Me and a different buddy were running late, and definitely stole a parking spot from someone while attempting to make it inside quicker. Get inside, and the same dude whose parking spot I just stole walks in a minute or two after me. Turns out, it was the judge. We lost that one, after the judge awarded bonus points to the other school. It was ostensibly for a very clever argument they made, but I maintain it was because he recognized me and my friend, and was unhappy about the parking spot. So I rested one case with a sneaky trick, and got another case ripped because of a parking dispute with the judge. Story 36. I'm not a lawyer, but I shut down the courtroom with this one. So I was a witness for the state in prosecuting a DUI case. In this case, I was a medic that did a blood draw, and I was to testify about why I did or did not recall the defendant was intoxicated at the time I found him in police custody. I didn't recall a whole lot about the specifics beyond what I wrote in my chart, but I knew for a fact I recalled him being intoxicated. The defense pressed me on why I thought he was drunk. The details I remembered. I had to do multiple sticks because he wouldn't sit still. He was an impatient punk making snide remarks. The defense kept pressing me why I thought he was drunk, though. That's not enough. I talked about how I probably see more drunk people than sober people, how many blood draws I do, the signs and symptoms I'm trained to observe in alcohol intoxication, how this is backed up by often learning their BAC at the ER, so I can correlate behavior with approximate levels of drunkenness, but none of that was good enough. Did I smell alcohol on him? I don't recall that specifically right now one way or the other. Did you give him a breathalyzer? No, I didn't. Did he admit he was drinking? Not to me. So, why then can you sit there in good faith and tell the jury you're so confident you remember he was intoxicated when you clearly have no memory of such a thing? And I replied with all honesty, if you really must know. After all that, I went to the ambulance, looked at my partner and said, man, that guy was a drunk jerk. So I remember at the time being convinced of both of those things. The defense seemed rather taken aback and had no further questions. I was ushered out of a very quiet courtroom, save for a few snickers from the jury. Story 37. Yesterday, I won a pretrial motion to suppress evidence based on an unlawful stop in violation of the Fourth Amendment. The officer's testimony as to his reasonable suspicion for the stop was based on an anonymous tip of people walking around the woods with a flashlight. My client happened to be driving through that neighborhood right after the officer concluded that there were no people in the woods. The officer saw my client's car, ran the tag, and saw it wasn't registered to the house my client was pulling away from. So the officer stopped my client and found he was driving while impaired. My client ended up getting arrested and blowing at the station for a .11 BAC, which is .03 over legal limit. On the stand, I asked the officer, what was illegal about people walking in the woods with flashlights? He said, nothing. And then I asked if my client was ever seen with a flashlight or walking near the woods. He said, no. So then I asked, so you pulled my client over because you suspected he was involved in an activity that wasn't illegal, and you had no indication that he was even involved in that activity? I was referring to walking in the woods, the tip that began the whole process. The officer responded, it just seemed odd that he was in the neighborhood, but his car wasn't registered there. That was my rest my case moment. In my closing argument, I pointed out that if the stop was deemed valid, then law enforcement could stop anyone if they felt a vehicle was in an odd location without any indication of criminal activity. Judge agreed. Motion to suppress granted, and all the evidence that was obtained after the stop was kept out. The state took a dismissal and I got a big hug from my client's mom. Okay, but hot take? Driving while impaired is kind of bad though. So I don't know how I feel about this guy getting off scot-free for it. Don't love it, I don't think. I get it, fair enough, you can't just be pulling people over for no reason, I guess. But also, drunk driving is stupid, don't do it. Story 38. Not a lawyer, but was working with our corporate lawyers on a patent infringement case. I was an engineer specializing in the technology in question, a document scanning system. At the time, we had a relationship with a company that provided OEM products for our lower-end scanning market, and in the meantime, we were working on a higher-end machine of our own design. As our new design was getting ready for the market, they accused us of violating one of their patents. The wording of the patent in question was very, very broad, and it indeed looked bad for us. They invited us to their HQ to discuss the issue and potential remedies. Best case, licensing fees. Worst case, back to the drawing board. We had met several times before the trip to prep, and despite the efforts of our engineering team, we couldn't find a hole in the patent. We flew out to their HQ, and upon landing, met one more time in the hotel lobby. We were prepared for the worst. It was then that I noticed some wording in the patent that was quite specific about the way the document scanning surface was held in place while the scanning head moved. Their patent described the surface resting on fixed rails, with the scanning head moving beneath it. However, because we were very concerned about maintaining a constant focal distance from the scanning head to the document, our scanning surface was captured by the head itself, not the rails, so that the document surface would freely track any minor up and down or twisting motion of the head due to rail deflection or dirt or what have you. In fact, if the head was not present in the machine, the scanning surface would just fall into the bottom of the unit. Well, the lawyers looked at me in shock. We talked it through, and they started grinning, and soon we were all smiling like idiots. It was bulletproof. We went into the meeting. They had their corporate lawyers, engineers, and business sector managers. And after all the righteous outrage was expressed along with the desire to somehow find a way forward and maintain a good working relationship, blah, 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 it was show and tell time. Our lawyer simply said, "We don't believe that we violate your patent." And using the prototype we had brought along, I showed them why. It was beautiful. They just sat there at first. Then their tech guys asked me to show them again. Then they left to have a private conference. We tried to keep it professional while we waited, but we knew we had them. They came back all apologies, saying how they hoped that our fruitful partnership could continue, as it had been so successful before. When we left, we went straight to a nearby bar and celebrated. By the end of the night, our straight-laced corporate attorney was all like, "I love you guys, man." It was a great day. Story 39. I'm not a lawyer, but I was pretty proud of this. Got a parking ticket for parking in an unmetered space. Yes, you read that right. I'd parked in what would normally be a metered space, but the parking meter had been removed. There was just an empty pole. I tried contesting online and got refused, so went to court. The meter guy was called up to testify, and he reported that he'd seen me in the space on such and such day at such and such time. Judge asked me if I wanted to cross-examine, and I said no. Judge asked me if I had parked there. I said yes. Judge ruled I was guilty, and I asked if I could ask a question. He said yes. What ordinance was I cited against? Judge asked the meter guy. All he said was that it wasn't allowed to park there, and that he'd seen me parked there several days in a row for longer than the allowed time in a metered zone and decided it was time to cite me. I kept my mouth shut. Judge asked the prosecutor what the ordinance was. He didn't know. Judge asked the clerk to look it up. They didn't find one. I knew because I'd done my research beforehand. Judge ruled not guilty. He also laughed and told me I was better at keeping my mouth shut when I should than many lawyers he'd seen. Presumably because had I admitted to parking longer than the allowed time in a metered zone, he could have cited me there for that. In retrospect, I should have asked the question when the judge asked if I wanted to cross-examine, but it's still a satisfying outcome. Story 40. Wasn't really a rest my case moment, but a good one. A few years back, my brother and I moved into this quiet apartment building. The property managers catered to the helicopter pilots who lived above us. Meanwhile, my brother and I were correction officers at the time. We kept getting the blame for our loud neighbor. Had a crappy day at the jail, come home to find an eviction notice on our door. It stated we have 10 days to get out of the apartment. We stayed and hired a lawyer for the tribunal hearing. Our lawyer during the hearing says, "I understand you have helicopter pilots living in the building. Well, these gentlemen are correction officers and have to be up early in the mornings as well. Are you telling me their jobs are not as important?" The two property manager ladies were stunned with that question. Lawyer continued, "So if we follow through with this eviction, we have to get all the complainants to take the day off of work to come in for this. Are you willing to make these people do that?" The two property managers were totally unprepared for this guy. The tribunal guy was even impressed. Felt pretty good to beat them at their own game. The two managers asked our lawyer in front of us and the tribunal guy, if we ever have any more issues with these two tenants, can we hire you?" He kind of chuckled at them and said, "I fight for the little guy." Story 41. We were in mediation on a case, and were close to settling, but we were just far enough apart that it looked like it wasn't going to resolve. The mediator comes in and tells me the vice president of this company I deal with all the time, who is like this 270-pound burly guy that my associate swears resembled Bam Bam Bigelow, says he will arm wrestle me for the difference. So essentially, if he wins, we take his final number. If I win, he pays ours. The mediator, who's a character, says it's crazy, but I should just do it. Then my client jumps in and says he wants to see this too, and he doesn't care about the money. Now, I'm 6 foot and 185 pounds, so I'm at a severe weight disadvantage. But I have always been weirdly good at arm wrestling, so I say screw it. Tell him it's on if he's serious. Mediator leaves. I put on some DMX and start bouncing around a bit to get worked up like a fighter about to enter a ring. Go into the room. We agree we're doing this. Shake hands and get set up. The mediator is bouncing off the walls, and we have my client and 2 other attorneys watching. Mediator says, "Go!" And just when I lock my arm and absorb this guy's initial push, then feel his arm give slightly when he realizes he isn't moving me, and I just go full force. Had him down so fast, my associate initially thought I lost. We shook hands again and went back to our caucus room, and my client was ecstatic that not only did I do it for him, but I won. And the mediator came in still giddy, saying it was the craziest thing he's seen in his career. He then said this guy is red-faced and frantically texting because he thinks he didn't have the authority to pay that much, and didn't contemplate actually losing. However, sure enough, and true to his word, minutes later we had the signed agreement. Then we went out for some drinks to celebrate, and within a day, it was legend in my office. Story 42. I was helping a client gain custody of his infant daughter. He insisted that baby mama was on drugs, and his first attorney tried in vain to get him to understand just how favorable our state is to 50-50 time, unless he can prove by a pretty high standard that she was on drugs. The problem is, he kicked her out because he had suspicions, but then one day found needles and a substance in the other baby daddy's bedroom. This was all wrapped up in an old dish towel with a band, the type you put around your arm for shooting up, I don't know the name, as well as a spoon. She tells him every frickin' lie. "I don't know, not mine, only tried it once," etc. But he refuses to believe her and kicks her to the curb. So he fires first attorney and hires me. I go straight into client control mode, heavily managing expectations, while I'm doing everything I can to put requirements in place to catch this drug use, and we're getting nowhere. The problem we have is it's a one-time thing, she's a good liar, even by legal standards, and we have nothing current to show a pattern. But he insists. So I file to restrict her time and we go to court. She is such a good witness and the judge buys every bit of it. On cross, she testifies that she only ever shot up the one time ever, and that's the only time she ever used anything illegal. And she just knew how to shoot up because she didn't know. I thought I had a pretty good cross. It took some time, but I felt like we got what we needed. But we lost. The judge gave her essentially 50-50 time, ordered us to mediation, and set up some regular drug screens. We go to mediation and put in place a parenting plan that sets up a little more detailed 50-50 custody schedule, but also requires regular urine drug screens and some more detail about those screens so we can be sure she isn't constantly trying to beat the tests. Best I can do with the facts. I caution him that all we can do is pay attention to the screens, stay on top of it, and take her into court under an emergency motion at the first slip-up, but she is so good. She's supposed to take the screens within 24 hours of her request, but always has an excuse and is just a couple days or so late. Also, somehow almost all of her screens are on Wednesday. Later find out a friend works those days. Also, mysteriously, she refuses to give me direct access to the screens but provides them to her lawyer who faxes them to me. I immediately start sending faxes. He was old school. No emails and a jerk, so no phone calls, and telling him that I consider this contempt and he better cure it or I will file. My client is furious at each contempt, but the standard for this is so high and we've already been in court once and didn't do well, so I really need to build a case. So finally, we get quite a few weeks of ridiculous behavior, and my more than reasonable attempts to address it with our attorney. I file for civil and criminal contempt and we go to court. An important detail is that she has another baby daddy who is fighting custody at the same time for the same reasons, and has required drug screens. I'd been in contact with his attorney and we were sharing information. I find out the night before our hearing she had completed a urine drug screen and passed it. So when we get there, I caution my client about getting his hopes up. Remind him, this is a long game. She's late. Judge starts without her. No craps given. Her attorney, surprised, withdraws. He says it's because of lack of communication. She finally shows up as I'm giving the rundown of my motions. I run through the timeline of missed screens, delayed screens, a screen that failed because her sample was too diluted, etc. And the judge looks at her and she gives all the excuses in her very sweet and innocent way. The judge listens, then asks how she would test that day. She says she'll be clean and they screen her. And she fails for exactly what we expected. The judge asks why, and she tries what are clearly excuses this time, changes her story to fit the facts, and he cuts her off, telling her he doesn't believe her. He orders her to 4 hours a week supervised visitation, and she has to pay dad support until she completes an intensive outpatient drug treatment program, at which time she can regain some of her custody. That little girl just turned 5 and mom has never visited, and to my knowledge, has never completed any treatment. She also hasn't paid a dime, which my client doesn't really care about and doesn't want to pursue. It's a small town. He said he saw her in a restaurant once and she walked right by her daughter and didn't acknowledge her. I've seen her out once with friends partying without a care in the world, it seemed. I can guarantee that kid is so much better off, man. What an incredible ending to this very long, admittedly, video. What a nice feel-good vibe. Like, okay, not feel great because the whole process took a while, the child's being raised under a single parent, which is a less than ideal circumstance, although single parents can be great, but it feel good because they're not being raised by a mom who clearly is negligent in more ways than just about children. I can't imagine that would have been the best parenting experience for them. So hell yeah, OP, great work. But for now, that is the final story of today. So thank you very much for watching. I hope you have a wonderful day or night wherever you are, and I will see you in the next one.